Okay, guys, these are the series of lectures that I've been promising you, and I'm delivering now. I've broken it into 4 separate recordings so that they're more manageable in size. And with that, we're going to start off. These will be the general topics we'll be discussing. I'll give you some general thoughts and ideas to consider while writing papers, and then I'll discuss legal and scientific research. That's the first talk. The second talk will be evaluating scientific research. Third will be getting from your outline to paper, which is to say, how do you develop your ideas that are in outline form into paper form? What are good steps to do that? Editing is a separate lecture as well, which has the plagiarism part on it, which I don't belabor. First, we'll, of course, start at the beginning, a very fine place to start. And I offer some general thoughts. In these papers, they're different from undergraduate papers, which are often merely descriptive. These are more position papers. You are going to be defining your position as a result. And you also want to explain case holdings and not confuse holdings from findings or the court's reasoning. This you know how to do. You've learned how to do it in LRW, but this is just a reminder. Use cases to support your position. Explain why any contrary cases are not persuasive. You can do that through a case exposition or however you best feel you can accomplish that. This is true for the first paper as well as the second. You're going to want to use cases to support your positions in that paper, just as you would in any other kind of legal writing. One thing that you should always do when writing anything that's persuasive, and this is a form of a persuasive document, you want to think about the holes in your argument or questions you would have if you were critiquing your own paper. And so if you're making a logical jump, recognize that and fix it. Change how you're doing that part of the paper. Recognize that you can find these things in your own writing if you take a step back. And finally, for general thoughts, use commentary from the literature, law review articles and the like, to support arguments you make. You can also disagree with some commentary and explain that disagreement. All of these, however, are things to generally keep in mind as you progress through the paper. Okay, let's get into conducting legal and scientific research. Before you worry, I'll be talking more about the structure and content of the paper in the 2 lectures from now, in the third part. Let's talk a little bit about something you should be comfortable with, legal research, and then something you may not be comfortable with, scientific research, literature research. I'm not asking you to go into a lab. Okay, legal research cases, we'll talk about in a moment, but just regarding scholarship. Now, by scholarship, I mean law review articles or other position papers written by scholars, by academicians who offer their opinions on various topics. And those law school publications are typically law reviews or other kinds of journals, but you have access to those on Westlaw through the JLR, which is the Journal and Law Review database, or TP All Treaties and Periodicals. It falls under that periodicals section. Once you've read widely, update the articles. What's widely? If you find a series of articles about a topic that you are interested in, be it for the first or second paper, read them together. Read them as a bunch to get a feel for where the literature is on this particular point. Then you update the articles. By that I mean you essentially shepherdize or key cite the articles. See who cites to them. That will give you ideas on where the literature might have gone since that article was published, because the articles could have a follow-on study, or you could see other prominent people who are writing a lot about this article. Read those publications as well. They'll give you a better feel for where the literature stands, be it the Fourth or Fifth Amendment issues in paper 1 or the paper of your choosing for paper 2. So stay away from websites as primary sources. I'll emphasize this later as well, but the only kinds of websites that are appropriate to cite, if you aren't citing them for a fact of the website being there, of course, are official sites, things with .govs or generally trusted websites. Wikipedia is not one of those. Generally, it's official sites, that's why I said .gov, or it could be an international treaty website like WIPO.int for the kind of work I do in patents. So you're really looking for official sites here. And that should be SITES. Okay, this you know how to do. Legal research on opinions. The cases on which you rely, of course, must be good law and cited for the correct proposition. This is all stuff you learned in LRW. It's dangerous, of course, to rely on old cases without reading in the area to make sure that the law is still good. Again, you know this. You can take advantage of the key site and shepherdize functionalities to figure out what's still good law. Okay, now we step into an area where you're probably least comfortable, and that's fine. A level of discomfort is what you would expect. When it comes to scientific literature research, I don't expect you to be perfect at all. I expect you to be able to comment intelligently upon what you're reading. If you have technical difficulties, come to me. I'll resolve those in plain language so that you can understand if that article or the findings in that article are relevant to what you're writing about. You should always contact me about those things. But when finding how to find scientific literature can be a little tricky for someone who hasn't done it. It's not that different actually from legal research, but still it can feel different at first. So you're going to want to use articles as background to help understand the subject and educate the reader. And this is that's how you're going to be using scientific articles. They could be used as background if you're talking about the data more particularly. If that's your jam and that's how you want to do it, you'll be talking about them in the body of the paper, and indeed you'll probably be using at least some in the body of the paper. But they are particularly helpful for background to deal with the subject and educate the reader. So are law review articles in that sense. Now, where do you get scientific articles? There's two great places to find them. First, Google Scholar. If you're signed up under Dory and go in a university browser to scholar.google.com, Google Scholar, you can just do plain language searches there. And if that article is freely available because Duquesne subscribes to that journal, then you will have a link on the right-hand side that will permit you to get a copy of that article for free. Not all articles are free, and I'll tell you how to address that in a moment. PubMed is a service run by the National Institutes of Health. It is located on Gumberg's website, so if you go over there and in the main search bar do a search on PubMed, it will take you there. Our librarians can help. If people are having difficulty getting to PubMed, I can record a separate lecture on that. PubMed is a great research tool, and it permits you to look at abstracts for all modern articles in the scientific literature. And also, many of the articles are freely available. It will say on PubMed whether or not there's a NIH provided free copy of the article Or, just like with Google Scholar, PubMed will tie in our subscription so that if you click on a remote site and we subscribe to the journal, we can get it. So both of those interfaces are great because they're plain language. Let's say you wanted to learn about fMRI-based lie detection. If you put in fMRI lie detection, you would get hundreds of articles back in each of these sites, I would expect. Definitely Google Scholar, and at least dozens, if not hundreds, in PubMed. So toss in search terms, see what you find. Start collecting things that sound interesting for either of your papers. And for the first paper, you won't need much science. I'm telling you to assume the science is true, right? But nonetheless, you can, if you want background into that, you can get it through PubMed and Google Scholar. Now, this is a way in which you can relatively painlessly use the information in technical publications. You don't have to hammer through the publications yourself. You're welcome to. I'll help you read those. It's a different set of skills to read that compared to reading an opinion. I have them because I went to school for that. So come talk to me. I can help you. But you can also use law review articles written by authoritative law professors to capture that information. In other words, you can cite to the law review article by law professor of prominence, and what she writes in her law review articles about the science, you can cite. Great example is if you want to talk about fMRI-based lie detection, I'd suggest looking at Professor Moriarty's legal literature. She wrote about it and writes about it still a lot. You can cite her, for example, for the technical propositions about fMRI-based lie detection if you want to write your second paper about that. That's the kind of thing I mean, and I'll expand upon any of this when we get to it in class. You want to trust research by authoritative scholars and scientists. In legal research, it's, of course, the courts define who is persuasive and precedential authority in that jurisdiction. It's a little different with scholarship in science. In science, you want to find out which articles and which authors are frequently cited in positive ways, published in good journals. And if you don't know what good journals are, ask me. You can tell in both PubMed and Google Scholar how many times an article was cited, and I could show you how to do that as well if you can't figure it out. On law, it's similar. You want to, of course, cite to the Supreme Court, federal courts of appeal, and state Supreme Courts as the appropriate authorities. But in terms of scholarship, you want to take the same approach as in science. Find out which articles and which authors are frequently cited in positive ways and published in good journals. Again, I can tell you which journals are good journals, but in law review, it's who you would think, the Harvard, Yale, blah, blah, blah stuff, right? But all those people who are writing there are people generally that the community has found authoritative, which is why they're in those journals. And finally, you can use some great treatises that are, I think, typically available through Westlaw and or Lexis. Here are a couple of great treatises. These are things like Murray on contracts, except it's on things that may be more relevant for this class. There's Fagman et al. Who have the treatise Modern Scientific Evidence. There's Gianelli et al. Who have scientific evidence. And then finally, I would put Professor Moriarty's text on expert evidence in this list. These are things you can work with the library to find. I have a copy of Professor Moriarty's expert evidence text. So those are the kinds of things that you can use as authoritative reference. Don't rely on these things. Don't cite Amger, CJS, Corpus Juris Secundum, or whatever stands for. ALR and similar compendiums. Cite the primary law. I don't want to see things that you read in the first week of law school to show you where books were. All right? Those are not authoritative things to cite. They're places to start to get ideas. Again, websites that aren't formal sites, as far as I'm concerned, are just a guy on the internet. That includes, I mean, you can cite to newspapers and the like, just not somebody's Reddit site or Reddit post. Generally don't cite to students, and it's not because they're putting out worse work than the quote scholars. It's just that they often don't have the authority that those quote scholars have, so it's not as good to cite to student notes generally. Bar journals like the Bar of the Western District of Pennsylvania, or the Journal of the Bar of the Western District of Pennsylvania, or the Journal of the Bar of the Federal Circuit, that kind of thing, are typically great for practicing lawyers and provide a lot of practice tips. They aren't authoritative or dealing with fringy things like academicians write about, things that haven't been worked out yet. They aren't for us. They are for a different time and place. This is an important point, but I think you get it. Don't pass off another scholar or court's interpretation of a case as if it's your own. Cite and quote. Don't, if you're making an authoritative statement and it's on your own, question whether that's an opinion that you're offering or something factual. If it's something factual or precedential in the law, cite and quote. Just cite and quote. And if it's something that is your opinion, that could be fine. You don't need a cite for your opinion, but just make sure you know when you're doing that. And I'll see you in the next part.